Share with us some examples of these outstanding legal principles that Sharia has shared with or contributed to universal legal development.
Well, as I said, in a time when despotism was the general rule and authoritarianism, and that there were no rights for the people at all in Middle Ages, during Middle Ages, Sharia said that the ruler should be chosen by the people and should be supervised and checked on by the people, and the people have the right to depose him, to get him out of the position if any serious injustice can be attributed to this ruler. With regard to civil law, as I said, the differentiation between the civil law and the commercial law, and making the commercial law more flexible. So, for example, it is required that when there is a civil contract, like a rent, for example, or lease between ordinary people who are not renting or having the place for business, but as an accommodation, it should be written, and there should be witnesses and so on. But in any transaction which is commercial, related to business people, this is not required. But in this case, honesty should be there and so on, and some ethical requirements. So you find in the civil and business law this accurate differentiation and this sensitive and intelligent observation. You find also in even in criminal law, in the penal law, the principles that nobody should be accused or punished except according to an announced law before the happening of the crime or the felony. And no penal law can be retroactive, can be applied to the past. So this principle of non-retroactivity of the penal law, you find this is very clear in the Quran itself, not only in the elaboration of the jurists, that any defendant cannot be considered really guilty if there is the slight doubt whether with regard to his responsibility that he voluntarily acted the thing and the crime, and he was fully aware of this, and he is able mentally and physically to know the results of his action, and also that this crime is really can be proved that this person had committed it. All these principles are in the penal law, and for any slight doubt the person should be set free and should be acquitted. In international law, that the war is the last resort, and you should go through peaceful negotiations. You should go through arbitration before going to war. And if it happens and the war comes out, the war should be conducted in a very humane way. Not only you fight the combatants, no effort, military effort should be devoted to civilians. Civilians should be exempted from any military effects. Not only that, you should not destroy this principle of destroyed land. When any person has to retreat, then he has to destroy everything. No, this is not allowed. You cannot cut a tree. You cannot kill an animal without any great justification. So all these were principles in Sharia which really were not only enlightening the Muslims, but enlightening the whole legal thinking.
Well, you talked about guilt or innocence, but to what extent are jurists saddled with fixed mandatory penalties for certain defined crimes, and how much flexibility do they have when it comes to the area of penal law?
Well, First of all, we have to keep in mind that all the crimes which have fixed punishment in the Quran and the traditions of the Prophet are four: theft, adultery, libel or slander, and then public order, which is connected with use of violence to disturb the public order by or through a use of violence. Not only stealing or theft, but theft with the use of violence, and making a sort of disturbance for the public order with the use of violence. These are the four, in addition to life sentence for killing and murder, which is agreed upon by many other laws, modern laws even. So it is four crimes which are having certain punishment, but the point is that the principle of not punishing any person except after being sure that the crime is committed beyond any doubt. Here, the jurists really put a lot of openings, a lot of ways to get the defendant out, because in this case, you cannot be sure that he has committed the crime without the slight doubt. For example, for theft, he should not be hungry. He should not be in need. And this is a doubt which can stop the punishment. If I find that the person was really in need and he wants just to eat or wants the money to bring medicine to his child or anything like this. So the circumstances of the person himself. Is he educated? Does he know the law? It is a precondition for any law, especially the penal law, in modern times and in Islam, to be known in advance. The crime and its definition, and the punishment and all its limits. But Islam adds to this not the supposed knowledge, the presumed knowledge, that putting it in the official gazette or in any way of announcement is enough and the people are supposed to know. No. In the Islamic jurists, of course, this can be changed if this is found needed in modern times, but in early times, in classical times, the jurists put a condition that really the defendant should know the thing, the law, realistically, not as presumed. So if he is, for example, a nomad in the desert, or he is an illiterate person, and at that time there was no radio, no television, no other way to know that a law has been issued, then he should be exempted from the punishment. And in this case, he may be punished by prison, by something else, by a lesser punishment than the hudud. So the hudud really are based on or are presupposing certain social circumstances, social justice, education, and unless all these requirements are there, you cannot practice or you cannot apply hudud. So as a matter of fact, I see hudud as a deterrence more than applicable punishments. Because going through these conditions, it is very difficult to prove that a person is guilty without any doubt, and he has enough needs sufficiently. All what he needs are there. He is educated. All this is very difficult, because there is a general principle which is very important in Islam, that the goal of the penal law is not punishing people. The goal of penal law is reforming and rehabilitation of the criminal to be an ordinary and a healthy and a good citizen. So if this is the case, then the judge, the court, is not fond of criminalizing people. As a matter of fact, in certain cases, a defendant came to the Prophet and said, I did so and so after the prayers. He told this, she was a lady, he told her, did you pray with us? She said yes. He said, that's enough. Okay, then there is no guilt. I don't think that we should go through the procedure if it has been proved that you have changed, because this deterrence is just an obstacle in front of a hindrance in front of the person to deter him or her from doing the thing. If he is deterred, and that's why if a person commits a crime and he was not seized in the same time and he was seized later, and it has been proven that all his behavior has been changed, there is no way to take him to court in Islam if this can be proved.